Welcome to Canton Confidential, the Karen Reed murder trial. I'm J.C. Monahan. Opening statements in the retrial are still on schedule to begin Tuesday. Right now, 16 jurors have been seated. Initially, that was thought to be the magic number needed. But yesterday, we learned the jury selection process will resume on Monday with the goal of reaching 18. Now, this is all happening as public interest in the case continues to grow under this avalanche of media attention. You may remember last time around, Reed's case was a bit overshadowed by President Trump's hush money trial in New York City. This time, perhaps you could say she has the national stage to herself. And come next week, there will be a media frenzy surrounding this high-profile case. NBC 10's John Maroney has a look at what to expect from Norfolk Superior Court in Dedham.
This is going to be the premier trial that people are looking at.
Karen Reed's retrial is expected to be bigger than the first, prompting comparisons with O.J. Simpson's, the mother of all modern-day media trials.
The strategy here is to reach that O.J. Simpson critical mass, to make this trial impossible to ignore.
15, how does that feel?
Feels good. It feels good.
The 45-year-old defendant says she's been framed, pleading not guilty to hitting her boyfriend John O'Keefe with her SUV and leaving him to die in a blizzard. In the latest Vanity Fair, Reed invokes O.J., saying, "I'm not saying I believe O.J. was innocent, but I believe that it was not a completely above-board investigation. Now that I'm smarter, I would have cheered at that acquittal. You have to hold cops accountable."
There is no doubt that law enforcement in both cases hurt the cases significantly by their actions.
Both cases include allegations of sloppy police work and investigators with what seemed to be axes to grind, namely Michael Proctor and Mark Furman.
Furman was more generalized racist behavior, where Proctor is specifically targeting Miss Reed with his comments and her medical condition.
Not guilty of the crime of murder.
In a nod to O.J., Reed supporters are selling Dream Team T-shirts online, as well as hoodies that say, "If Chloe bit, you must acquit." David Gerzoff Richard is CEO of Big Fish PR and a professor at Emerson. He says there's one big difference between the two cases.
Social media was not a thing back during the O.J. Simpson trial, so everybody was glued to their TVs watching the white Bronco driving down the highway. This time around, it's going to be delivered to our cell phones in real time.
John Maroney, NBC 10 Boston.
All right, let's bring in NBC 10 courtroom insider Sue O'Connell, and let's dig into that Vanity Fair article a little bit. We were both around for the O.J. Simpson trial.
We were indeed.
So we remember that. So in this one, she talked about the police investigation, basically the federal investigation into the police, which they say is over and done with. Matter of fact, Hank Brennan, the prosecutor, said he confirmed that with the U.S. Attorney's Office. Reed disagrees. This is what she said in Vanity Fair, quote, "Everyone should note which side of my case is celebrating the federal investigation supposedly being closed and which side isn't. That will tell you which side of this case is culpable and therefore worried about a possible federal indictment." That's just the latest public statements. Let's not forget 2020, Dateline, the indie docu-series that was, 5 parts?
Right.
When you're out there, because you're at the court every day and the public is there, are you hearing anything about how much she's been talking? People may be changing their opinions or thinking she should maybe quiet down, or no? Do they love it?
No, I don't know if they love it, but I think the situation is, of course, as you know, the lawyers aren't allowed to speak. There's a gag order on them, of course. So Karen has been taking up that mantle of discussing the case with people. And I would say that one thing Karen Reed has been consistent about is who she is. Her personality has not changed. I don't think we're going to discover any way that she says something or talks about something that is surprising and shocking, right? So I don't think she loses anything by being out there saying what she's saying, being who she is. She's not going to convince anybody that thinks she's guilty that she isn't, nor is she going to repel anybody who thinks that she's definitely not guilty, thinks she is based on what she says. So, you know, I don't hear a lot from people reacting to the fact that she is speaking out. And again, she's on brand for her. She's saying what she's thinking, and she does not seem to be totally concerned about if it might have a negative impact on the outcome of the case.
Or words twisted, or,
right.
There are all these opportunities for that to happen. She also talked about the lead prosecutor in the case, which is Proctor, and we all know that he is no longer with the police department because of these text messages he said about Reed and the case. And if you hadn't heard, his family, his wife and sister, released a statement defending him. And this is what Karen Reed said in response in that Vanity Fair article. She says, quote, "All the statement did was put his vile behavior back in the news cycle, and he had to use 2 women to do it. Can't he speak for himself?" And then I have to read this because I want to get this right. She also linked Proctor to Matt Damon's corrupt state trooper character in The Departed. We know that's a Boston-based movie.
The Boston movie.
The Boston movie. So you mentioned she's taking the lead in terms of being out there in public, but she's making some pretty bold statements.
Right. I actually don't disagree with her at all around the Michael Proctor statement in that why do you keep bringing up something that's going to keep it in the public eye? So I think that, if she's going to open a media consultancy company after this, that was the good advice. And I would push back a little bit on what Michael Coyne said earlier about how what Proctor said was about an individual. It wasn't about a group.
Yes.
Like Mark Furman was obviously talking about a group. He was being racist. I would push back and say if you're immediately calling a woman the C word and immediately talking about her disability, that's how you think of the group. Okay, even if it's just among your friends or just among your coworkers, most people who don't think that don't say it, right? So I think that she is busy right now trying to continue that narrative. I think this O.J. Simpson conversation that she's having is also trying to paint her in the same position where whether I did it or didn't do it, the case against me is flawed, and here is why, and here is the framework I want you to think about. Now, again, there's only a couple more jurors to go.
Right.
So it's not like we're reaching out into the future of the jurors.
Changing the jury pool.
Right, or
this.
influencing the jury pool, as
whatever.
defense and prosecutors might say. But I think she is really trying to take the narrative and stick it to something that we can all at least understand from an intellectual standpoint.
Sue, as always, you're going to be with us every day.
Yes, I will be. You're welcome.
Is he guilty of any offense charged?
He is.
Guilty of what?
He's guilty of voluntary manslaughter.
That was the verdict yesterday in the trial of a doctor from Dover charged in the death of his wife. Ingolf Turek learned his punishment in the very same courthouse, the same courtroom that not only hosted Karen Reed's first trial, but will be the site of her retrial. Jurors found Turek guilty of voluntary manslaughter in the 2020 death of his wife, Kathleen McLean. On the stand, he admitted to strangling her and dumping her body.
And I blacked out from the struck. I was assaulted at this point in time, and I reacted, and I believe I grabbed her.
When you black out, are you saying you passed out?
No, blacking out means that I didn't really recall what I was doing. I reacted to a threat.
So
I snapped.
All right, jurors acquitted Turek of the more serious charge of first-degree murder. Turek's defense attorney said his client was found not guilty because he acted in self-defense.
Jury obviously put a lot of work into the deliberations. The evidence, I think, was there. They listened to the judge. They applied the law to the facts. The evidence was so compelling that the jurors, looking at it objectively, just felt it clearly. There was no malice here and no intent to kill.
All right, here's why we're talking about it. He was acquitted of second-degree murder, which is just one of the 3 charges that Karen Reed is facing. So now let's bring in attorney Morgietta Dorsey. We're watching the trial of that man, and again, he was found not guilty, even though he was on the stand saying, yes, I did it. And we can't get into all the semantics and all the legal part, but the point is he got up there and said he did it, and they didn't find him guilty of second-degree murder. We have Karen Reed saying quite clearly, I did not do this, and we still have a second-degree murder charge that's on the table there. Looking at both cases, does it confirm to you the prosecution should have pulled that one, or you still think it should be on the charges against her?
I think a lot of people and non-attorneys as well have said that it was an overreach from the beginning. And I think that's quite evident with the fact that after the first trial, jurors came forward not only with that charge, but, another charge. the idea is that you have to remember first-degree murder requires intent. It requires premeditation to actually commit this crime. And it's really hard to do that if you don't have the evidence that aligns with that. So is it an overreach? I still think it is. It's really hard to get into the mind of Karen Read and really say whether or not she intentionally meant to do this. It's really hard.
When you're talking about that, Hank Brennan, who's now leading the prosecution, he heard the jurors. He heard what the defense said leading up to this retrial, that jurors came out of the woodwork saying, no, we said she was not guilty on charges 1 and 3. And as you look at it, you'd say, okay, so he didn't pay attention to any of that. He didn't take those off the table and say, we're just going to focus on 2. Is there a strategy there? Because from an outsider with no legal experience whatsoever, it would seem to me if you can focus on 1 and not dilute it, that maybe it would be an easier convince?
I think you have to weigh the balance, right? So you have a family that is trying to get justice for their loved one, and you also have, you know, an element of whether or not this person did this particular crime. And I think coming in, he is probably looking at this from a fresh set of eyes, fresh new witnesses, fresh strategy, and perhaps with the information that he believes he has, and, you know, they have this new engineer coming in, maybe they believe that with this new information they can prove that. But it is one of the hardest types of charges to prove because that element of intent is so crucial.
Right.
So crucial.
Here's where it gets even more so. They have appealed to the U.S. Supreme Court. Second, but they appealed to, can we hold off on the trial until the Supreme Court decides whether or not to take up their appeal on double jeopardy. They said, no, go ahead, get the trial going. Then on the 25th of April, they're all going to convene and consider whether or not they will take that up, because you've mentioned a lot that they get a lot of cases before them they don't take up. The U.S. Supreme Court doesn't talk about it, all of them. Okay, so let's say they take it up. Then what happens? We're in the middle of the trial while the Supreme Court is trying to debate whether this is double jeopardy. And could we finish the trial before we even get a response?
So again, I think we have to look at the trajectory, right? You've already had several other courts prior to the Supreme Court pretty much deny this. And I don't think it's a surprise that the Karen Read team has a high burden to meet, right, in terms of getting this issue of double jeopardy kicked out. They've also already petitioned on an emergency basis to stop the trial, and that was also denied by the Supreme Court. So again, the likelihood that it's picked up and moved forward while this trial is happening is highly unlikely. But if it does, it would be another unique set of circumstances with this case. But I think the fact that the Supreme Court denied their emergency petition kind of set the wavelength that they want this case to move forward in the Superior Court. So I think we should focus on that. And I think, again, just to Justice Canoni's point, it took a lot of energy and effort just to get this trial going and just to get these jurors in place. So it has to move forward unless there is an order otherwise. I wouldn't be surprised if the defense team renewed their motion, but they would have to have really good grounds and really new information. But I'm sure they're going to do it anyways. I see this trial moving forward.
You see it. All right. And that right now is set for Tuesday. We just need Monday to pick up maybe 2 more jurors.
A few more jurors, yeah.
So then get rest this weekend.
Yes.
Because off and running we shall be. Thank you so much, Morgietta, as always. And we love it when you guys let us know what you want us to talk about. If you have any questions about this case, send them our way. We have the email right there up on your screen, canton.confidential@nbcuni.com. We will answer as many questions as we can. And of course, remember, NBC 10 Boston is your source for everything related to the Karen Read retrial. So be sure to join us weeknights at 7 for a full recap of the day's court proceedings.